Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, as you know, for those of you who've been geeking out on this channel for a while, we routinely talk about really bad news. In fact, most of the thing that our state and federal governments do to us pretty much sucks. However, once in a blue moon, there's a little silver lining to a cloud, and this may be one of those cases. So let us all rejoice. Because when we start to take a look at what's happening in the appellate courts, when we start to take a look at what's happening in jurisdictions that candidly are not particularly 2A friendly, we're beginning to see a trend that for us in the lawful and responsible gun owning community might be rather encouraging. So today, let's spend a few minutes and talk about, is time already running out on magazine bans? Okay, so the issue we're talking about yet again today, and we have talked about this issue ad nauseum, and that is magazine bans. Now, for my Washington viewers, I know we are incredibly hypersensitive to this issue because just this past legislative session, that is in March of this year, engrossed Senate Bill 5078 was passed, which now went into effect July 1st and has limited magazine capacity to Washington State to 10 rounds. Now, granted, there's a lot of grandfathering provisions and things like that, and we've covered all of that stuff in all of these videos here, so we're not going to be rehashing that. Now, for those of you where I've had the pleasure of speaking to live in the last couple of months, I've been mentioning in kind of my 2A update section of my self-defense presentation that I do believe that Washington's magazine ban could be one of the shortest-lived magazine bans in the history of the United States. Why do I say that? Well, I say that because of a case called Duncan V Bonta. Now, we have talked about that case in videos here, and many of you have been geeking out on this channel. You know about this case, but we're going to give you a little bit of current events as it relates to Duncan v. Bonta. We'll start with a little historical perspective. We'll give you some current events. And when you see what's going on, you're going to feel very encouraged. And then I also want to talk to you about something that's happening in Washington, D.C. that I also think is pretty encouraging on this. Okay, we're going to use some handy-dandy graphics here to help kind of explain the long and sordid history of Duncan v. Bonta and where it sits today and what this means to you. But as we know, in 1989, the state of California, of course the state of California, passed the first ever United States magazine ban, limiting magazines to 10 rounds. Now, they, like Washington State, started off with the restriction of commercial sales, eventually tightened up the law by merely adding the word possession, and essentially turned millions of lawful and responsible gun owners in California into criminals overnight. Now, in the case of Duncan v. Becerra, there was the first legitimate challenge to California's magazine ban. Now, the case was named Duncan v. Becerra because that's Javier Becerra was the Attorney General of California at that particular time. Now, that case was heard in the Southern District of California in San Diego before the Honorable Judge Benitez. The issue was whether or not Judge Benitez would find the law unconstitutional, the magazine restriction, and issue an injunction which would stop the state of California from, in fact, enforcing that law. Judge Benitez issued a ruling, a very clairvoyant ruling, as a matter of fact, when you take a look at the language that he chose, in which he basically said, listen, we use a very strict analysis when we're analyzing constitutional gun legislation, and under this, I cannot find any type of a history or any other support of magazine bans, therefore it is unconstitutional. Victory number one. He also issued an immediate injunction which basically halted California's magazine ban laws, which meant, that's right, Freedom Week. And there was like a week where Californians could live like they were almost back in the United States again, and purchase large capacity or magazines of greater capacity than 10 rounds, okay? Now, of course, the state of California, which never likes losing, immediately appealed to the Ninth Circuit. And there was additional amendments made to this injunction where essentially the state of California had to stop selling the magazines, but those that had purchased in that limited little Freedom Week or window of time, the injunction was to keep California from enforcing that law against them during that particular time. So, California appeals to the Ninth Circuit. Hey, listen, it's the Ninth Circuit. That's where every piece of gun legislation will always survive, okay? If you got a good Second Amendment argument and you want a place for it to go die, try the Ninth Circuit. But wait, a 3-judge panel reviewed the ruling of the lower court, Judge Benitez, and said, wait a second, no, he's right. Now, they did employ a mildly different analysis. They got more into that 2-part analysis, which we'll discuss in a minute, but they still, even though they used the wrong test, they came to the right conclusion and said, no, we agree with Judge Benitez. There's no constitutional support for this. There's no historical support for this. And for that reason, the injunction remains. Hallelujah. Okay, California's freed. Well, of course not, because the state of California again flips out, and now they appeal to the entire Ninth Circuit, the en banc panel of 11 judges. And everyone in the 2A community will tell you that once we got to that point, we kind of knew that the game was over, because the Ninth Circuit Court, for those of you who follow these things, knows that they're so far left, if the world was flat, they would fall off. This is where every piece of gun legislation is typically given 2 thumbs up. And not too surprisingly, the Ninth Circuit did overturn the ruling of the lower courts and found that California's magazine ban was in fact constitutional. Shocker, and away we go. Now, what happens at that point? Well, now Duncan decides, hey, listen, I'm appealing that. I want to go all the way up to the United States Supreme Court, okay? And so when we petition to the United States Supreme Court, what we're doing is what's called a writ of certiorari, which is a fancy Latin term for, hey, I'm asking for an invitation. The Supreme Court gets to decide which cases they hear, and one of the criticisms over the Supreme Court over the last 14 years or so was their unwillingness to accept many important Second Amendment cases, including magazine bans from other states, including California, Maryland, and other states, AR bans and other restrictive gun measures, and they just, for whatever reason, didn't want to touch it with a 10-foot pole. Along comes New York Pistol and Rifle Association v. Bruin, though, and that case does get accepted. And so what happened with Duncan v. Bonta, as well as 3 other cases that we've talked about in this video right here, is it kind of just put all of them on hold. Hey, pause, let's see what happens here with Bruin, and then we'll decide, are we going to accept review or what are we going to do with those cases? So the ruling comes out in Bruin. It is a glorious day for the Second Amendment. Not only does New York's rather oppressive and ridiculous concealed carry laws get thrown out, but more importantly, Justice Thomas clearly defines once and for all what the legal test is moving forward when we're going to be analyzing the constitutionality of gun control legislation. And taking away the second part of that rather cute but unnecessary 2-part test and focusing only on the first part, which is, is this type of activity typically protected by the Second Amendment, and are any restrictions of it supported either through the history or through text? And without that, then in most instances, that legislation should be deemed unconstitutional. Okay, after the Bruin opinion came out, then we were all waiting on bated breath what's going to happen with these other 4 cases, including Duncan v. Bonta. What did the Supreme Court do? Well, we talked about it in this video right here, but what they did is they vacated, and they remanded the case. GVR, grant. They granted review. They said, yeah, we're going to accept review of this case. That's good news. But then they went 2 steps further. They vacated the ruling of the lower court. Without even hearing arguments, they said, you know what, Ninth Circuit, you got it wrong because you applied the wrong legal standard, so we're vacating that ruling. And we are remanding it back down to the Ninth Circuit so that you can rule consistent with the correct legal framework as announced in Bruin. So they punt this back down to the Ninth Circuit. So now what does the Ninth Circuit do with it? Well, does the Ninth Circuit really want to say, all right, you're right, we were wrong, we applied the wrong legal standard, and now we'll apply the correct legal standard, and yep, California, you can no longer have a magazine ban. No, they simply can't swallow their pride and do that. So what they've done is they punted the case all the way back down to the Southern District of California, to the trial level, back in front of who? That's right, Judge Benitez. Now, what's the good news about that? 2 things. Number 1, let us remember that Judge Benitez originally ruled in favor of the plaintiff here and found California's law unconstitutional. And number 2, if you read his opinion, he actually applied the correct legal analysis. He was very clairvoyant because and I don't know if Justice Thomas kind of cut and pasted from what Judge Benitez did, but their rationale is quite similar, and of course, so is the result. The other good thing is that the rumor is Judge Benitez does not like to mess around, and apparently an order has been issued in which he's already set schedules, he set argument schedules, briefing schedules, and all of that, and we anticipate a ruling from Judge Benitez by December. Now, in addition to all that good news on the West Coast, there is additional good news coming out of the East Coast, specifically Washington, D.C., because, see, there is a case out there, Heller versus District of Columbia. No, not that famous Heller versus District of Columbia from the United States Supreme Court, but is it that Heller? Yes, it is, and obviously it's that District of Columbia. The Heller Foundation had sued the District of Columbia because they have a goofy little law that if you are actually granted the ability to conceal, carry, and carry, you can only carry enough ammunition to reload your firearm twice. However, it's actually capped at 20 rounds. So the bottom line is you can carry no more than 20 rounds of ammunition. In addition to that, they also have a 10-round magazine restriction. The Heller Foundation sued the District of Columbia over this first law capping the number of rounds you could carry to 20 rounds. So, what did the District of Columbia do? Did they fight this? No. They actually repealed the law. Let me say that again. They actually repealed the law. They said, all right, you know what? You're right. It's a bad law. So they repealed it, and now they're in settlement conference with the Heller Foundation so as to not get a published opinion that would basically strike down that law. But think about this. If the District of Columbia has already acknowledged that a limitation on the number of rounds we can carry in defense of ourselves is unconstitutional, then would not their other statute, which appears to limit the number of rounds a person can carry in defense of themselves, also be unconstitutional? And so we were beginning to see in even some of the strongest anti-2A communities, like the District of Columbia, an acknowledgement that these magazine restrictions simply do not pass constitutional muster. Do I believe that we are going to have very positive news before the end of this calendar year? My prediction right now is yes, I do. In the meantime, you may have more questions about magazine restrictions or anything else related to your Second Amendment rights. Remember, you can always contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.